Following a 17-day trial, the court issued a 329-page judgment, which established the following important facts and conclusions. 1. Contrary to the Workers' Party's claims, including claims made in Parliament, there was no urgency that warranted the waiver of the tenders for the managing agents and services under the Essential Maintenance Service Unit, or EMSU. The court found that Mr. Lau Tia Kiang and Ms. Sylvia Lim had deliberately delayed calling a tender in order to provide themselves with a convenient but false excuse to waive the tender. In the trial, the Workers' Party accepted that they only needed 2 months to call a tender. They could have asked CPG, the previous managing agent, to continue providing managing agent services for far longer than that. They had ample time to call for a tender, but deliberately delayed doing so in order to create an excuse not to call a tender. This conduct is inexcusable. In fact, the court found that there had never been any intention to call a tender in the first place. The 2 Workers' Party MPs had already decided on FMSS within days of the 2011 general election and had hid that fact from other councillors. They were determined to appoint their friends. They admitted in court that they had decided to engage FMSS. They also admitted that they had rejected other parties who were interested in providing managing agent services. And as I said earlier, if one wants to appoint one's friends, there is a proper, transparent process to do so. The Workers' Party deliberately chose the wrong way, and the 2 hid the truth from their own town councillors and the public. Among the Workers' Party's town councillors, they had one experienced town councillor who had been chairman of another town council for 20 years, and they had 3 lawyers. They should have known that a tender could only be waived under very special circumstances. And they should also have known that these special circumstances did not exist when they waived tender in this case. If they had called a tender and their trusted friends had been the only bidders, they could then have appointed their friends. Even if there had been several bids, they could have still chosen to appoint their friends, provided they acted honestly and properly. Explain why they were appointing their friends, record the reasons in the minutes, and be prepared to defend the reasons in public. But they admitted in court that if a tender had been called, there was a risk that someone else might have put in a bid. Indeed, there were other parties that had expressed an interest to provide managing agent services to AHTC. They admitted that if someone had put in a bid better than FMSS, they would have been duty-bound to consider that the bid. And they knew that FMSS would not have got the job if they had said they would only accept the better bid. So they were not prepared to take the risk that would have come from being honest, appoint their friends despite receiving better bids from others, and explain to the public why they have done so. But they were prepared to run the risk that came from being dishonest. And so they claimed they had no time to call a tender so that they could appoint FMSS without a tender. As I said, the right way was to go before the Tender and Contracts Committee to justify the decision to appoint their friends and have their reasons documented. Furthermore, and this is extremely important, if they want to appoint their friends, then they should have made sure that their friends charge less and not more than their previous managing agents. The previous managing agent was an established institution, while their friends had set up a fledgling company, which, as they admitted in court, had no experience in managing a town the size of AHTC. The court found that Ms. Lau Tia Kiang and Ms. Silver Lim had been fully aware that their conduct regarding the waiver of the tender was of questionable integrity. And to cover up their wrongdoing, they consciously and deliberately misled their own fellow town councillors, their own auditors, their constituents, and Parliament. As the High Court put it, there was a deliberate and calculated plan to, I quote, cloak and camouflage their wrongdoing. Mr. Speaker, sir, this is a most serious finding. It means they knew that what they were doing was wrong, but nevertheless persisted in the wrong. And they deliberately set out to mislead everyone, including their own colleagues in the town council, so as to hide their wrongdoing. Mr. Speaker, I would now like to distribute Annex 3 to my speech. May I have your approval?
Yes, please.
Annex 3 is a compilation of the Workers' Party's misleading statements. The Workers' Party misled their own town councillors. They deliberately kept the decision to appoint FMSS away from a town council meeting. Instead, they delegated authority to Ms. Sylvia Lim so as to keep the other town councillors in the dark. They concealed their true motives from the rest of the town councillors. The Workers' Party misled their own auditors. Most disturbingly, Ms. Silver Lim asked Ms. How Weng Fan and Mr. Danny Low to sanitize the reports on FMS's appointment as managing agent so it could, I quote, pass the auditor's eyes. Pass the auditor's eye. And she's a lawyer. Mr. Danny Low was asked to draft the report. Ms. How Weng Fan and Mr. Danny Low were the very officers and shareholders whose appointment was to be approved without tender. And here were Mr. Lau Tia Kiang and Ms. Silver Lim asking them to draft a comment on the report concerning their own appointment. The judge considered this to be extraordinary and stated these actions cast serious doubts on their honesty and integrity. The Workers' Party misled the public. In the Town Council's press release on 5th August 2011 concerning the appointments of FMSS, they falsely asserted that there was no time to call a tender. The judge found that this misled the public and the very constituents the MPs were elected to serve. As the judge put it, and I quote, there was a concerted attempt to cloak the appointments of FMSS with a veneer of propriety in order to camouflage its true motive, unquote. The press release also falsely asserted that AHTC did not incur additional managing agent fees from appointing FMSS. Under cross-examination, Ms. Silver Lim admitted that this was not accurate, before finally admitting it's not true, and that she knew it was not true. She then had to agree that she had lied in the press release, which was disseminated to all Singaporeans, including the residents of AHTC. The Workers' Party misled Parliament. The judge found that it was not sufficiently urgent to justify waiver of tender. This means that when the Workers' Party told Parliament in 2015 that they waived tender because of urgency, they were misleading Parliament. Ms. Sylvia Lim said in Parliament in 2015, I quote, "For the first contract in 2011 for MA services, it was triggered as the incumbent MA, CPG Facilities Management, asked to be released from the contract with the TC for business reason. There was an urgent need to put in place a computer system due to the termination of the former system in use," unquote. Now, the judgment was crystal clear on this. And I quote, "There was no urgency or public interest that warranted the waiver of tender. It was neither CPG's announcement on 30th May 2011 nor AIM's withdrawal of TCMS that resulted in the tender being waived," unquote. In waiving tender, Ms. Sylvia Lim and Mr. Lau Tia Kiang's, and I quote, "conduct was improper and the attempt to cloak the same with a veneer of truth and credibility collectively leads to the conclusion that they had not acted honestly," unquote. Mr. Speaker, sir, why were there so many false and misleading statements? When one reads the record, the AGO report, the KPMG report, the PwC reports, 3 court judgments, you will find misleading statements made by the Workers' Party MPs piling up. In some, waiver of tender was not justified, but they did this to appoint their friends. They knew that this was wrong and thus misled their own town councillors, misled their own auditors, misled the public, and misled Parliament to hide their wrongdoing. Ms. Sylvia Lim and Mr. Lau Tia Kiang not only misled Parliament, they also knowingly allowed Mr. Pritam Singh to mislead Parliament. Mr. Pritam Singh said in 2015, and I quote, "Where FMSS is a tenderer in a tender called by the Town Council, as was the case in 2011 for the managing agent contract, FMSS is kept at an arm's length and the China wall is built between FMSS and the Town Council," unquote. We now know this to be false. The court found How Wing Fund had been heavily involved since early May 2011, soon after the general election, in setting up FMSS and in a plot to keep CPG in the dark. She was involved in the preparation of the FMS's letter of intent, and as I noted earlier, in sanitizing the report on FMS's appointment as managing agent for the auditors. Ms. Sylvia Lim and Mr. Lau Tia Kiang knew very well they had not kept How at arm's length. Yet, they let Mr. Pritam Singh mislead this House without correcting him. When the Workers' Party's leaders let their own MPs mislead Parliament on their behalf, what does this say about the Workers' Party's integrity and values? The Workers' Party also misled Parliament that their safeguards for transactions with their friends were adequate. Ms. Sylvia Lim told this House in 2015, and I quote, "It was a policy that no cheque to FMSS of whatever amount could be issued unless either the Town Council chairman or one of the vice chairmen co-signed the cheque. Thus, it was not possible for FMSS to pay itself unless it was authorized by the Town Council chair or vice chair who have no interest in FMSS whatsoever," unquote. Mr. Peng Eng Huat said, and I quote, "Our managing agent cannot make payments to themselves for the above services without the chairman or one of the vice chairmen to co-sign the cheque," unquote. Now, these are half-truths at best, because in reality, there was no standing instruction that co-signatures were required on cheques for payments to FMSI, the EMSU provider. In fact, these claims are entirely untrue. Ms. Sylvia Lim admitted to the court that she did not personally check that each payment was justified. Despite all the reassurances they gave, there were payments to FMSS without the requisite co-signature of members of the Town Council. Mr. Speaker, sir, everything I presented is based on objective facts as established in court, after having heard the defendants under oath. The court found that Mr. Lau Tia Kiang and Ms. Sylvia Lim had breached their fiduciary duties, had not been honest, and questioned their integrity and lack of candor and transparency. Ms. Sylvia Lim remains a vice chairman of AHTC, while Mr. Lau Tia Kiang is a member of AHTC. Almost 4 weeks have passed since the court judgment. The Workers' Party has been totally silent on this matter. So has AHTC. This is why I have to ask in Parliament, what does the current chairman of AHTC, Mr. Faisal Manap, intend to do? At the minimum, will he apologize to residents of Aljunied-Hougang for letting them down? An apology will be the first step, a belated recognition that they had let residents down and an intention to put things right. Is he going to require the MPs so severely judged and found wanting by the court to recuse themselves from the Town Council affairs pending the disposal of any appeal they may file? Very serious adverse findings were made against them, findings that go to the heart of the integrity of these MPs and the deceptive manner in which they conducted the Town Council's affairs. How can they remain in charge of the Town Council's affairs as if it's business as usual? At the very least, should not the chairman and other town councillors require them to recuse themselves from handling the Town Council's financial matters as called for in this motion? Until the appeal is, if any, is over, will Mr. Faisal Manap remove Ms. Sylvia Lim as vice chairman? Or will he allow her to continue to be in a position where she can co-sign checks on behalf of AHTC? If AHTC were a company, Ms. Sylvia Lim and Mr. Lau Tia Kiang would, at the very least, have been interdicted, prohibited or restrained from acting pending their appeal. Most likely, they would have been forced to leave the company a long time ago, when AGO and then KPMG made their findings, instead of being allowed to carry on in the same roles and enjoying the same degree of financial oversight over public funds. If they were members of a professional body, and many members of this House are members of professional body, their acts of dishonesty would have brought them before a disciplinary tribunal. As the earlier judgment of the High Court noted, they might have been exposed to civil liability or, in extreme scenario, to criminal liability. And in light of how they have misled this House and the absence of a response by the Town Council, I would like to know what, if anything, the Workers' Party's remaining MPs and NCMPs propose to do about these findings pending any appeal. Will they at long last be conducting their own investigations, or will they continue to dodge and deny? As Secretary General and Chairman, respectively, of the Workers' Party, Mr. Pritam Singh and Ms. Sylvia Lim are responsible for party standards and discipline. Both are themselves involved in the AHTC problem. But it is still their duty to act for the Workers' Party. Will they apologize on behalf of the Workers' Party? will they direct Mr. Faisal Manap to do the right thing to protect AHTC's governance? Will they temporarily stand aside themselves and allow some other Workers' Party CEC member to take charge of this matter? Again, a standard practice in the corporate world. If nothing is done from now till the appeal is concluded, we will be forced to conclude that the Workers' Party, by its inaction, in fact endorses the dishonest conduct and the breach of the fiduciary duties that's already occurred and is complicit in the wrongdoing. I hope that the Workers' Party will take action. There were other financial and governance lapses which occurred in AHTC. The Workers' Party has put them right, albeit after a long delay and after denying and resisting for many years. In doing so, the Workers' Party have shown that they are in fact capable of taking steps to put their house in order when further obfuscation and delay at last becomes untenable. Last year, KPMG found that AHTC had finally resolved all the lapses flagged in past audits since 2013. I've detailed earlier how the Workers' Party initially resisted the appointment of any independent auditor, then resisted the appointment of a Big Four accounting firm. Finally, with the court intervening and with the government's offering to pay for the accountants, KPMG was appointed. Almost 2 years after KPMG was appointed, AHTC finally cleared the audit. I'm sure that the town councillors will agree that they are the better for the audit and that their controls and processes are now much safer. Sometimes a bitter pill has to be taken so a sick system can be returned to health. Similarly, now that honesty, integrity, candor, and transparency of some of the most senior Workers' Party members have been called into serious question, by the High Court no less, will the Workers' Party be willing to swallow another bitter pill and take action? If the Workers' Party wants the privilege of representing Singaporeans in Parliament, they cannot be silent on this.